This is SJC-12927, Glenn Christie v. Commonwealth.
Mr. Rangaby, on behalf of Mr. Christie, you may proceed.
Thank you very much, Your Honor. David Rangaviz for Glenn Christie. This morning and afternoon, this court has listened to over 4 hours of argument concerning difficult issues of systemic importance to save as many lives as possible across the Commonwealth. In that time, over 3,000 people in the U.S. have been diagnosed with this virus. Over 70 people have died from it. The extraordinary nature of this moment is reflected in the extraordinary nature of this argument. And I represent just one of the lives at stake, Mr. Christie, who stands out as an example of someone who's been placed in very serious jeopardy from this pandemic. If this court wants to provide guidance to trial judges, I ask that you recognize Mr. Christie as the archetype of inmate in need of protection and authorize his immediate release. I submit it would send emphatically the wrong message to the trial court to continue to hold this man who is vulnerable to the virus, who is near his release date, who is held on technical violations of probation, and is now in the only facility that we know of with a growing and ongoing outbreak. To deny release to Mr. Christie in these extraordinary circumstances would, I fear, be taken as precedent and as a license by trial judges hearing any of these release motions, and it would send a signal that would thwart any systemic remedy, and more people will die. And Mr. Christie's life will continue to be in very grave danger. As ADA Padalano said, release is the just and humane thing to do. And Mr. Christie told me, in speaking to him this morning, I asked him if there's anything he wanted me to communicate to your honors, and he said, just tell them that I'm genuinely afraid for my life. There are only 2 medical providers in this facility, he tells me, and one of them has already tested positive. So as we stand here today, this facility is on the cusp of an overwhelming outbreak, and there's only 1 medical provider left standing. Now, Mr. Christie told me this morning he thought the number of people there diagnosed were 17. Mr. Anderson has said the same number, 17, so I'm glad those numbers match. So, I would disagree with counsel in the prior case. They are not safer in these facilities. We've gone from 10 cases to 17 just over the matter of a weekend. Now, it's proceeding exponentially, and we all know just how quickly this virus spreads. When this petition was filed, there were no cases in the Department of Corrections. Then we proceeded through the Superior Court. When the motion to renew was filed, there were 4, and now there are 17, even though we proceeded incredibly quickly in this court. And the DOC attorney also represented that 2 cases were sent to local hospitals, which is 2 fewer hospital beds for the community. So we know this won't stop. We've seen it. It will continue to grow exponentially, and the only upper bound is the number of people housed in this particular facility. And I would just urge the court to recognize Mr. Christie as a unique and exceptional candidate for release. He is 11 months into a 1 to 2 year sentence for technical violations of his probation. And I don't say technical to dismiss the violations. I say technical to be descriptive. I think we all know what that means. There's no allegation of new criminal activity. With good time credit, he's within 6 months of his release. He's 54 years old. He suffers from a number of disorders, hypothyroidism, kidney disease, spinal stenosis, and he's currently awaiting confirmation of whether his past thyroid cancer has returned. So he falls into many of the categories of people for whom the emergency petition in the systemic litigation sought relief, many separate categories that would entitle him to relief under the proposed emergency legislation in the general court. But a 1 to 2 year sentence should not put his life in jeopardy. This is not remotely the sentence that was imposed, and on that score, I emphatically agree with Mr. Ralph's argument from the prior case. Now, like many of us, he's been terrified for the past 2 straight weeks, and he is not in a facility, and again, I disagree with the counsel for the DOC, he is not in a facility where they are practicing social distancing. He's in a small 6-man dorm room. When he needs medication, he lines up in the dormitory hallway with 50 to 60 other people. This is not the sort of physical distancing we've all come to practice in our daily lives. He's in very serious danger right now. He suffers from many overlapping conditions that place him at high risk for complications and death, and the outbreak is spreading in his facility, and he can't avoid it. He can't control the risk. He can't social distance. The risk is entirely out of his control, and he does not deserve what will come to him if nothing happens. Justice in this case will not be done, and I would ask you to authorize his release And with that, I would welcome your question.
And I will note that Justice Link is also recused on this matter, so Justice Gaziano is the senior justice. So Justice Gaziano, you may proceed.
I have no questions, Chief. Thank you.
Justice Lowy.
Yes, thank you. In the opposition, we are told that one of the reasons for the violation was missing 1/3 of the sex offender treatment meetings. Do you agree with that?
I agree with that only in the sense of he was not at those meetings, but I have, in my motion to reconsider, I did explain a number of those, and a number of them they are not anything that could remotely be described as willful. So the suspension letter lists 12 missed dates. One of those missed dates was actually canceled by the program itself.
Why don't you tell me what the number is, best case scenario for Mr. Christie, of how many he missed?
How many he missed without any forewarning and with no reason? He missed 2 meetings.
Okay.
And he was suspended from the program for less than a month, and he resolved it so quickly that he resolved it prior to the violation hearing. And I do want to note that the opposition seeks to portray Mr. Christie as someone who does not behave consistent with court orders, and that is just not consistent with the reality of this case. He was deemed acceptable by the program every single month that he participated in it. So he did miss those 2 meetings, but even in the month where he missed those 2 meetings without explanation, the program listed him as exceptional. So he had what is required by due process. He had no notice that this was not only going to lead to a suspension from the program, but actually a violation of his probation. And if the primary purpose of probation is rehabilitation, he was never terminated from the program. So the woman who ran it never thought that these missed meetings were actually made him not amenable to rehabilitation and continuing in the program. And then the other 2 bases are missing a meeting with his probation officer because he had 2 days prior been in the hospital overnight and tried to explain himself in 3 separate calls, being late for a restrap of his GPS device after it broke for no fault of his own, because of a massive fire that shut down the blue line. It was the casket fire in East Boston, the casket company fire in East Boston. So these are just not the sorts of violations that would make one think that Mr. Christie would not abide by any conditions that this court would set. So I would ask the court to take all of that into consideration. And I'm not trying to relitigate the violation hearing, but to the extent Mr. O'Sullivan in his opposition is trying to portray Mr. Christie as someone who does not comply with court orders and court set conditions, I do think it's germane to look at the basis of the violations and see that they're largely not willful, and there's only really 2 missed overall meetings from a program that he was just ordered to complete. And I, of course, cited the Bino case in my reply, where the appeals court basically said that, you have to be discharged to run afoul of such a completion condition. So I would urge Your Honor to note that when considering this case.
Okay, thank you.
Justice Budd.
Yes, Attorney Rangovich, tell me, what do we do with the fact that the Superior Court and I believe the Appeals Court both found that your client presented a danger to the community? I mean, and that he also is unlikely to commit additional criminal acts. And I understand the criminal acts part, and I understand he's in a wheelchair. But what do we do with their findings? Do we have to find them clearly erroneous?
Well, Your Honor, I would ask the court, especially since we're here under 211.3 and under rather extraordinary circumstances where all of those findings, of course, predate this entire pandemic issue, I would ask the court to take a look at those findings anew and see that the convictions in this case for conduct 15 years ago, they represent the entirety of Mr. Christie's criminal record. There's been no allegation of any similar conduct either before this 15-year-ago episode or since. And as you noted, at present, Mr. Christie, he cannot even walk. He, as confirmed by a physician's assistant at the Boston Medical Center in my appendix to my motion to renew on page 57, the community itself is now in lockdown. The circumstances have changed. Any opportunity to commit a crime is considerably narrowed, and he's going to go into lockdown as well himself because, he'll thankfully be removed from this enclosed congregate environment in which this virus is spreading, but then he'll be in a quarantine. So he'll be quarantined in a wheelchair during a lockdown of the entire community. So it's hard to imagine a case where the scales could be tipped more strongly in favor of his release, especially when you consider just how vulnerable he is to this virus. I mean, some of the numbers in the studies out of Wuhan, I think, are cited in my motion to renew about just how significant the risk to his life is when someone has these comorbid conditions. And these are not things that were ever considered in those findings in the Superior Court that were weighed against this. So most especially Justice Dickoff's finding, which the opposition portrays it as being only about a month ago, but sort of a lot's happened since then, as we all know. And then considering the actual bases of his violations, he missed a meeting with his probation officer because he was sick. He got suspended from a treatment and immediately reinstated, and he was delayed from fixing his GPS device because of a massive fire that shut down the Blue Line. He's already served 11 months of the 1 to 2 years, but this is not the sort of conduct that justifies putting his life in such serious jeopardy. So I do appreciate those findings, but I would ask the court, given the extraordinarily changed circumstances, to both consider the new circumstances and reconsider the old ones, given that no such balancing has been done before.
In terms of the earliest release date, I think your papers said June or July, but it wasn't, it didn't correlate with what the probation department had. Do you know what it is?
Yeah, I think the Department of Corrections in the hearing before Judge Tochka represented that with good time credit, he would be due for release just within 6 months. So it would be, I think it was sometime in mid-September. I don't remember the exact date. And his understanding was that it could be as early as late July, but he may have been mistaken about that. I don't think he knew that exactly correctly. I think would be the most likely thing given the DOC's representations on our prior telephonic hearing. So I think it's within 6 months, being mid-September.
Okay. And in order to release him, it would have to be cruel and unusual punishment, right? I mean, we would have to find deliberate indifference. Is that correct?
Well, I don't think you would necessarily have to find deliberate indifference. I mean, I think it could be something, for example, could be done under this court's extraordinary power under 211.3. It could be considered the sort of circumstance that requires revision of the sentence under a suspended Rule 29. And again, I agree with ADA Ralph's representations about how this is not the sentence that was intended at the time it was imposed, and therefore it's a basis to revise the sentence. One point I would just make in addition to all the points that ADA Ralph made is the Tejeda case, which is about a co-venturer's sentence that comes after the defendant's sentence. That was deemed something to be important enough to justify suspending the limitation on considering new circumstances and new facts in a motion to revise and revoke. And I would submit that if that is considered something that's important enough to consider something new that's developed after the time of sentencing, the same should be true when there's this sort of unprecedented global pandemic, when, as Justice Lowy wrote there, the underlying principles that govern Rule 29 are fairness and justice. I don't think this court necessarily needs to find that there's necessarily cruel and unusual punishment. But even if you disagree with me, I think some of the sheriffs and the Department of Corrections think that the petition, at least the systemic petition, to which I was also co-counsel, was intended to in any way cast aspersions upon them. And as we clarified in our reply, that's not what we were intending to do. We're not trying to cast blame for it, but these are inherently dangerous environments that the risk cannot be mitigated because of what we've seen in these congregate environments. We just saw, I think, in the paper, the tragedy of what's happening in Holyoke with 13 deaths in the nursing home. We've seen this happening in Seattle. So to do nothing in this situation, I think would not recognize the risk that is inherent to the correctional environment in these facilities. And as all the public health experts said in the submissions in the systemic case, it would save lives to thin out and reduce the density of these facilities, not just of the incarcerated people within them, but also the staff and the broader communities, because every person that gets taken out of one of those facilities and gets put into a community hospital is one less hospital for somebody who lives in that community. So both for the public health reasons of the people inside and the people outside, we need to do this on a systemic basis, but I think Mr. Christie also stands out as uniquely deserving and uniquely needing to be released as well, given his vulnerability to this virus.
Okay, thank you.
Thank you.
Justice Seifer.
Yes, thank you. Counsel, I've read the papers, but there's been a lot that's happened since. Can you refresh my memory of what the crimes are that he was sentenced for?
Yes, Your Honor, certainly. So he was sentenced for multiple counts of I can just pull it up. Multiple counts of rape of a child, and then there was a reversal on appeal, and then I believe it was in June of 2018, he then pled guilty to those charges and was placed on probation. So those are the charges.
And then the violation of probation, did that involve any contact with any of the previous victims?
No, certainly not. No, I can explain the bases of the violation of probation, if Your Honor
so I just want to make sure. Yeah. It didn't involve contact or anything like that. That's fine.
No, I can't emphasize enough. It certainly did not. He missed one meeting with his probation officer because he missed one meeting with his probation officer because he was sick, and the other things I've already described.
Right.
So no, it was no allegation of
I
abuse.
understand.
Yeah.
Okay. No further questions. Thank you.
Justice Kafka.
So I remember there's an issue with the friend he says he's going to live with. What do we know about the friend he's going to live with? Is it any?
Yeah, I mean, so as the Chief Justice said, I mean, we've done the best we can in the prior case, we've done the best we can with the release plans under the circumstances. I did speak, actually to his friend, yesterday evening, and, she's someone who lives in Revere. I can tell you her name if you'd like. She lives in Revere. She has no children who live with her or visit her. She's indicated that she has grandchildren, but she's actually estranged from her daughter. So she doesn't see her. She was sad about it. She doesn't see her grandchildren anymore. So no children will be living with her or visiting her anytime in the near future. She said that she's aware that Mr. Christie happens to be in the facility with the ongoing and growing outbreak, and that she would be willing to have him quarantine himself in her home. So that's the option there. Mr. Christie has also told me about a friend of his in Pittsfield who is referenced in the probation submission, and I haven't been able to speak to that friend of his, but Mr. Christie told me that friend has also told him that there would be possibility of staying with him, but that would take him, obviously further away. But, of course, as we laid out in our release plan, which was updated with the motion to renew, any treatment that he would start, particularly the mental health providers, who I think it's important to note who he was seeing above and beyond the terms of his probation, including Justice Lowy, those 2 missed meetings with the court-ordered program. He was seeing on a very consistent basis 2 separate mental health counselors, the one at the Lynn Community Health Center, the other at a place called Circles of Care, and they both indicated that they would continue to see him on a kind of similar to how I'm seeing you all now, on a video conference line or an audio meeting line. and and they would welcome him with open arms back into treatment. So, he would have, his release plan would be going to live with this friend who I can tell you as an officer of the court I've spoken with and is willing to have him quarantine with her and has no children living with her. At that point, he would then restart his health insurance and try to start planning for the spinal surgery that he needs to walk again, but he won't be having that anytime in the next 2 weeks, because I think coming from this facility, I think the responsible thing for him to do, and I think he's planning to do, is quarantine himself, and then during that 2-week period of time, he would take up the mental health treatment that he was doing both as a condition of his probation and beyond the terms of his probation. And then he would get the spinal surgery that he needs thereafter once his self-quarantine lifts. And if he's able, given everything there's obviously some inherent uncertainty here that is beyond his control, but he would then try to go get the treatment that he needs in order to be able to fix some of the cysts on his spine and the spinal stenosis that is pinching his spinal cord and making him unable to walk. So that is the plan that he's got going forward, and then from there it would be rehabilitation and trying to find an independent place to live consistent with the letter from the social worker that we submitted with our original motion. And I've also been in touch with that same social worker whose CV is in my submissions to this court, and she's indicated that she is, I'm sorry.
I just wanted to switch subjects because I think we have enough on that.
Okay.
And Justice Lowy will be more familiar with Tejeda than I will be, but Tejeda, we allowed a motion for a new trial right because the co-venturer I can't remember, got a very short sentence or a shorter sentence. Is that what we did? We didn't do a Rule 29 in that case, did we?
No, that was a Rule 29.
That was a Rule 29 case. Okay.
Yeah, that case was a Rule 29, and Justice Lowy's opinion,
But
allowed.
It was within 60 days, or we allowed it even though it was after 60 days. I'm less sure about. We can figure that out. We'll look it up, but I just was.
Yeah,
I want to make sure I understand.
I would, and Justice Casper, I would assume that it was probably within 60 days because the case mostly discusses the exceptions for new information. So there's no discussion of lifting the time limit.
Okay.
So I think that was mainly focused on that. So I would guess it was within the 60 days.
That's all I have. Thank you.
I've got a few questions. With respect to the sentence that he received ultimately after the reversals, it was a pure probationary sentence. There was no custodial sentence imposed.
No, he'd served 6 years at that point. So as an agreed disposition, he got 6 years deemed served, and then he was placed on 10 years of probation.
Okay, so it was a 10-year probationary period. Was it 6 years deemed served, or was he sentenced to that, or on a separate count?
I think it was 6 years deemed served, and then he was placed on probation on 2 counts.
I see. Okay, so with regard to that, as I understand it, Judge, you had the judge whose sentence was Judge Brieger. And then it went back ultimately to Judge Tochka. And I believe it was February 14th that it was Valentine's Day, I think, that Judge Brieger denied it. And then it was February, denied by, February 27th, I believe, or 26th, correct?
I think 26th, yes, Your Honor.
So when it went back to Judge Tochka after it had gone initially to the single justice, that was February 27th, so that was before this thing broke open.
Well, it was before Judge Tochka after the initial petition was denied. So 2 weeks ago, I filed the initial petition before in the single justice session. That was denied, And so then I effectively renewed the motion in the Superior Court to exhaust the trial court remedies, and then it was denied by Judge Tochka the following Monday.
Okay.
So that was,
and he, I believe, denied it because he had understood that the appeals court single justice, who I believe was Justice Ditkoff, had already ruled on that. Is that correct?
well, that was certainly part of his analysis. Part of his analysis was also a belief that he didn't actually have the authority to rule on that. And then part of his analysis was something else he said in that analysis was that he didn't actually think that Mr. Christie's risk of contracting COVID-19 was actually higher in the facility, which I think is also quite incorrect. And then another point that he made is he didn't think I think in terms of his analysis of the public safety risk, he largely agreed with the analysis of Justice Ditkoff, which obviously preceded this entire thing. But one point that he made was whether Mr. Christie would be more likely to contract COVID-19 at the treatment center if he's not immediately released is pure speculation, which I think, given that we've gone from 10 to 17 cases over this past weekend, I think is quite incorrect. By that point, I also, the woman, the friend of Mr. Christie's works in healthcare. She told me yesterday she's been working double shifts every day. She called me in her 15-minute gap between shifts. And she basically said, that she told me everything I just reported to Your Honors, and I didn't have any of that information when I was, before Justice Tochka, last week. So that's another thing that's changed is I think we have a little more clarity because Judge Tochka also said it's not clear that he would quarantine himself. And now I can represent to Your Honors that I've spoken to someone who's willing to take him in and have him quarantine himself. So he doesn't present the danger to public health that I think Judge Tochka feared at the time because we didn't have some of that detail.
And did we have, by the way, his ruling in the record? I couldn't find it.
I believe it is appended to an amended opposition filed by Mr. O'Sullivan, I think would be the place to find it, because he didn't, Judge Tochka did not issue that written ruling until after his oral denial of the motion, which was just during the telephonic hearing. So it came after the hearing, and I think it was emailed to the parties the same day that Mr. O'Sullivan's opposition was due. And because he got it that same day, I'll let him speak to this, but that's why he amended his opposition and added it there.
I see. Okay. So is it, certainly, of course, you would want us to simply order his release. I understand that. Is it also your argument that the matter should properly go back to Judge Tochka because he's not bound either by the ruling of Justice Ditkoff or by his own ruling because of a change in circumstances?
Well, Mr. Chief Justice, I would ask this court to authorize his immediate release, primarily being when I filed this petition, there were no cases in any DOC facility. Now we have 17 in Mr. Christie's very facility. This process, as extraordinarily fast as it's happened, we can't outrace this virus. It's growing every day. One of his roommates has already been taken out of his room, of his 6-man room, and a couple of days later, correctional staff came in with personal protective equipment and took out all of the man's possessions and all of his clothing. So Mr. Christie is terrified that any further delay will lead him to contract this virus and put his life into very serious jeopardy. So I think that's something, of course, Mr. Chief Justice, that this court could do, but I think given the extraordinary circumstances, that it justifies the extraordinary action of this court, not only doing this to save Mr. Christie's life, but I think a lot of trial judges, as this court works on a systemic remedy, are going to take their cues from what this court does in this case with someone who falls into so many overlapping and dovetailing categories entitling him to relief under actions that have been taken in other jurisdictions and even in proposals in Massachusetts. So I would urge this court to authorize his immediate release.
All right. Let me ask one more thing. With regard to the issue of stay pending appeal. There are two prongs, of course. One is whether it's worthy of presentation to an appellate court, and your argument, I'm sure, is that, of course, it is, based on that there being technical violations, and there's some question as to whether those were willful. The other issue is the one of security, and generally it's, of course, not only the risk of flight, but the potential danger to any other person or to the community. Is it your argument that, in view of the pandemic, we need to consider security in a way we never have before, which is that consider the possible danger to the inmate himself arising from the denial of the stay?
Well, I think it's both the danger to the inmate himself. I do agree with that, but I also think it's something that is echoed in Dr. Sivashankar's affidavit appended to our reply in the systemic litigation, that we're all interdependent in this pandemic, and any risk to the safety and health of inmates inside of these facilities will cascade into the broader community and will affect everyone. So I think it's just a simple recognition that public safety has to include public health, and it includes the health not only of incarcerated people, but also correctional staff, their families, and their broader community. So we know that every inmate who comes out of that facility who needs a bed is one less bed for anybody in the community. So I do think it's something that should be recognized in any assessment of any sort of public safety risk that this would cause. And of course, Mr. Christie is just one person, but this is a systemic remedy that we're seeking, and every individual person is one less person to transmit the virus and one less person to take up a bed. So I do think that's something that should weigh significantly in that prong 2 calculus. I agree.
Okay, I have no further questions. Justice Galziano, any questions to follow up?
No, thank you.
Justice Slowey?
Yes. Could you tell me, what do you think our standard of review here is as it relates to the security danger issue posed, considering the determination by Judge Tochka and Ditkoff?
I would submit, Your Honor, that it should be considered de novo, given how difficult it is to really weigh these factors, given how much has even changed just since Judge Tochka issued his ruling last week, and how many more cases there are in the treatment center. And also, I think under any standard of review, for example, Justice Ditkoff's ruling, he says, just as by way of one example, that even if Mr. Christie is successful in his argument about the willfulness of his violations, he still doesn't comply with court orders. But that doesn't really hold water, right? Because if his violations are not willful, then he does comply with court orders. So I think actually the prong 1 sort of analysis, the reasonable possibility of success, just how, in my view, just how clearly not willful, at least 2, and I would submit that the 3rd violation as well of these violations should weigh in the balance as well, and be something that by any standard of review is not entitled to be accepted by this court on appeal. So that would be my submission, that I think because of how much is constantly changing, de novo review is appropriate, but by any standard, that sort of, view of these facts, is not supported by the evidence as well.
How about what we know about this family friend that he would stay with is only that she's a healthcare worker who will be doing double shifts, so presumably he'd be home alone most of the time. And that's all we know.
Yeah. Yeah, I think, I wish I'd had more time to get an affidavit from her or to have a long conversation with her. She did mention having a significant other who was a gentleman who she lived with. So I don't know if Mr. Christie would be entirely alone in her place. But her primary things that she mentioned to me are that she'd be willing to have him quarantine there. She has a separate bed and room for him. And she has no children who not only don't live with her, but they don't visit her so he would have no access to children. And she works in healthcare, and she's been working a lot of double shifts recently. So that's primarily the extent of the representation she made to me.
Thank you very much.
Thank you.
Justice Budd, anything else?
No, thank you.
Justice Seifer
No, thank you.
and Justice Kafker.
Two things. One, this case is not like the harder ones we're dealing with in the other case, right? Because we don't have to find a constitutional violation. We just have to find that there's an erroneous violation of probation, right? This doesn't raise the stakes that we're dealing with in the bigger case where we're dealing with people who were properly violated at the time. You're questioning the propriety of the violation itself, right?
Yes, and I do think that's something that should weigh substantially in the balance when you consider how the strength of the prong one showing. You know, when I argued, for example, the Alvarez case to this court, Justice Seifer, the Chief Justice, asked me questions about whether particularly strong showings on prong one could affect the analysis of prong two, because, you know, if you have such a strong argument on prong one, you know, someone should be out if they're going to win their appeal, for example. And I do think that's exactly right. I'll end my answer to you, Justice Kafker, by saying yes, I agree with you.
The second thing is he's living with a healthcare worker. I take it she's on the front lines of the coronavirus crisis. So isn't he in more danger there? I'm confused by why that's a safe placement for him.
Well, I don't think he'll be in more danger there because, one, I don't necessarily know if she is on the front lines of the crisis. I don't know if she works. I don't know exactly what her job is. She told me she works in healthcare, and so she's been working a lot of double shifts. I don't know if she works on the administrative side or if she's actually a direct provider. And even if she's a provider, if she's someone who's actually would be seeing COVID patients. But I think also, I think the bigger danger and the thing that I really wanted to verify with her is that she wouldn't be concerned about the danger he would pose to her, which is why when I talked to her, the thrust of my conversation was, are you sure that he can stay with you because you know he's in a facility that has 10 and probably more, when I talked to her, I think it was 10 or 13 at that point, people who have this virus, are you sure you'll be safe? And she said, you know, he's a good friend of mine. We have an open room. I'll quarantine myself from him. So I was more concerned about making sure there was protection in the opposite direction, and she was able to assure me that she felt comfortable with that.
Okay, that's all I have. Thank you.
And I have no further questions. Thank you, Mr. Rangavis. Mr. O'Sullivan.
Thank you.
Your Honor, if I may, Mr. O'Sullivan and I discussed, and we're thinking that perhaps probation could go first.
Okay. We'll let probation go first.
Thank you, Your Honor. Mr. Chief Justice and members of the Court, Sarah Joss on behalf of the Massachusetts Probation Service. Probation has not taken a position on whether or not Mr. Christie should be released, but has raised a number of concerns that I think echo the concerns that were raised in the systemic litigation from this morning, mainly issues around release planning and concerns around access to treatment and GPS. We've obviously now had some more detail from Mr. Christie in terms of what his release plan would look like. In ordinary circumstances, that would be the kind of thing that probation would do checks on to ensure the, access to children, that, even if there are no children living in the house itself, is it part of a bigger apartment building? Are there children in the building? Are there schools nearby? Those kinds of things. But because of the moment we find ourselves in, probation does not have the ability to do that kind of check. So I think that highlights a number of the concerns that were raised in the argument this morning about the need to have very clear detail in front of a court when it is weighing these public health and public safety considerations. To Justice Kafker's most recent set of questions, it's really tough to weigh out what those public health concerns are if there is not sufficient detail about someone who's potentially being released, about the plans that they have for where they're going to live, how they're going to self-quarantine, and who they're going to be in contact with, who are those people in contact with. That those are very tricky and detailed questions that it's not easy to answer in a categorical way. So obviously the fact that Mr. Christie has now provided some more information is helpful, but without further detail, it still raises concerns about the ability to verify this and to ensure that it is not creating additional risk factors. Secondly, I know Mr. Christie, part of his initial motion talked about the need to access additional treatment on the outside, including for surgery and things like that. Obviously, in the moment that we're in, the availability of that kind of treatment is ever changing. So I think that that is probably not something that factors in terms of the ability of him to access treatment for his underlying conditions, because I don't think anybody can guarantee at this point that even if he'd had surgery scheduled when he initially filed the motion, I don't think there's any guarantee that anybody could look forward to say at this point that that's going to happen anytime in the next few weeks. Certainly not, obviously, as counsel said, before the end of a self-quarantine period. And the third thing that probation raised below and that Judge Topska considered, and that remains a concern here, is that Mr. Christie, as part of his probation conditions, has a GPS condition. Probation had asked below in the Superior Court that if the court were inclined to release Mr. Christie, that it stay any GPS installation for the period of self-quarantine, or if Mr. Christie develops
now exiting
Scott Kafker.
Frank Gaziano.
Hang on, have we lost,
Yep.
have we lost Justice Kafka or Justice Gaziano?
It seems so.
We get them back. Is someone texting them?
I'm going to,
I'll do that.
I'll call Justice Kafka on his cell. Justice Kafka.
now joining, now exiting, now joining.
Frank Gaziano. I apologize. I was bounced out of the call.
Yeah, Justice Kafka says he's trying to call in right now.
Was Cap bounced?
Yes.
You have Justice Kafka yet?
Now joining.
Do we have Justice Kafka and Justice Gaziano?
Yeah, I'm here as well, Chief.
Okay, I don't know what happened. Fortunately, it didn't happen earlier. So, you were speaking, Ms. Joss, about GPS.
Yes, Your Honor, thank you. So probation raised below in the Superior Court and would raise the same concern here that where Mr. Christie is coming out of a facility and is planning to, if he's released, self-quarantine, probation would ask that any GPS condition that Mr. Christie were coming out to be stayed for the period of self-quarantine, and if Mr. Christie were to show symptoms during any period of recovery. Obviously, that cuts down on the disease vector that both Mr. Christie could be to the probation officer and to the extent that the probation officer was exposed to anything, for the probation officer to expose Mr. Christie. As I'm sure the court is aware, the installation of GPS requires close physical contact between the person doing the installing and the person who the bracelet is being installed on. On a good day, the process takes about half an hour. And that's, if everything is going well and according to plan. Obviously, no guarantee that that would be the case. And in addition to the actual physical installation of the bracelet, the probation officer has to have a lengthy conversation with the person who is going onto the bracelet to get all of the information about how to contact them, where they're staying, and all of those things. So that, I apologize for the dog in the back. So obviously that raises significant concerns if there's any period of self-quarantine or symptoms. So where probation would ask for, if Mr. Christie were released, a stay of that condition, Judge Toczka factored that in as part of the public safety considerations that, particularly given the history, GPS is something that the court relied on in increased monitoring of Mr. Christie and the unavailability of that 14 days, because Judge Toczka said that he would not have required probation to put it on and would have, were he inclined to release, would have stayed the condition. Obviously, that raises some additional public safety concerns. I think the overall issues that probation wants to raise here are that these are incredibly fact-intensive cases, both from a public health and a public safety perspective, and that every single case requires a balancing that needs sufficient factual fleshing out of release plans and quarantine and all of that. And so when we go back to the issue for Mr. Christie himself, I think those are the main concerns that probation has. And I would factor into that also that when someone is released on conditions at this point, generally speaking, the ability to monitor and enforce any of those conditions is going to be incredibly limited. There is no in-person contact between probation officers and probationers right now. So to the extent that the court is considering release, I would request that it keep in mind the limited ability that probation has to actually monitor and enforce conditions.
Mrs. Casiano.
No further questions. No questions, Rather, Chief.
Justice Louie.
No questions, please.
Justice Butt.
I'm wondering whether there are other conditions that Mr. Christie was on before that you're concerned that he's not going to be able to comply with. I understand the GPS issue.
Certainly, Your Honor. And I certainly all credit to Mr. Christie's team about reaching out to the Counseling and Psychotherapy Center, which provides the majority of sex offender treatment in the Commonwealth. And I believe it's in the appendix attached to Mr. Christie's petition in the single justice session that talks about CDC talking about the availability of treatment online. I think we are in a and while that may have been accurate at the time, I think we are in a continually fluctuating environment in terms of treatment. So CPC does not have an unlimited number of providers, and if any of them were to get sick, I think we continue to face a challenge with the availability of treatment. Treatment will continue to diminish in the community, and so I think that that's something that, while it may be available now, there's necessarily any guarantee that that will continue to be the case. And obviously, given the history here, and I know Mr. Christie has a different view on this than probation about the probation violations and whether or not they were willful, but I would simply note that both on the reconsideration motion in the Superior Court in front of the sentencing judge, Judge Grieger, and also in front of a single justice petition with Justice Fabiano, the request to reconsider that was denied. And Mr. Christie put forward in both of those circumstances all of the evidence about why he contended that his violations were not willful. So I think coupling the failure to comply with the treatment condition previously with the tenuousness of continued treatment in the community, I think raises some concerns as well.
Okay, but just to be clear, I mean, we're here because of the COVID-19 virus. That's the changed that's what has changed between that submission and now. And I guess my question to you is, you sort of laid out the difficulties that you will have in terms of monitoring him, but that's the case for anybody on probation at this point, right?
I think that's true. I think it's going to continue to be true, and it's going to continue to be ever shifting. So just to Your Honor's question about are there other conditions that we're concerned about being able to monitor and enforce, I think that's true for everybody. I think given the history with Mr. Christie and sex offender treatment, that raised a particular concern here.
Okay, thank you.
Justice Pfeiffer.
Nothing, thank you.
Justice Kafka.
No, nothing further.
I've got a few questions. Was he on GPS before?
He was, Your Honor.
He was.
Yes, and
was there an exclusion zone?
there were not exclusion zones.
So, as I understand it, we're not even permitting GPS without exclusion zones. So,
does he have named victims?
He does, Your Honor. The only thing I would say, Your Chief Justice Gantz, is the OE 144 about the new orders for GPS. I'm not sure that this would be a new order since it's part of his previously ordered conditions of probation. And when the Superior Court sentenced him on the VOP, the court sentenced him, revoked on one count, committed him for 1 to 2, and reprobated on the other. So technically, he would be coming out to a pre-existing order.
okay, but he would still have to be affixed by a probation officer.
Yes, yes.
Right.
But just in terms of
is there
exclusion zones.
Is there any particular, I gather there was no request for an exclusion zone from the victim before. Is there any particular concern of re-victimization of that victim?
Not that I'm aware of, Your Honor. I know there were also additional allegations of unsupervised contact with minors that were denied in the Superior Court because there wasn't a time frame that was attached to them. But I don't know that there are any concerns about this particular the underlying victim in the underlying case.
So, if he were to be released, there would need to be arguably a house arrest would have to be. But essentially, he'd be under house arrest. Basically, he'd be quarantined anyway for at least 14 days. So he should be under some type of provision to enforce the quarantine, correct?
I certainly think that would make sense, Your Honor, and I know that that's been on some bail reviews. What we've been hearing coming out of some courts is where GPS would not meet the conditions set out in OE 144. Courts have been ordering home confinement without GPS. So I think it would be something that would be in line with what courts are already doing.
Okay, I've no further questions. Anybody else have any questions?
No, thank you, Chief.
Justice Chloe?
No, thank you.
Justice Bud?
No, thank you.
Justice Pfeiffer?
Nope, thanks.
Justice Kafka?
Nope.
Okay, now Mr. O'Sullivan, on behalf of the Commonwealth.
Good afternoon, Your Honor, and David O'Sullivan for the Commonwealth. May it please the Court. I will be brief. The lower court did not abuse its discretion in denying release, largely because the court at that point lacked sufficient information to make key determinations as to whether release was consistent with, first, public safety, second, public health, and third, the defendant's own health and safety. I'll note at the beginning that this is the first, obviously, we're hearing of the defendant's actual release plan insofar as we've just now learned with whom he will stay. We don't have the name or the address, and obviously these are things that probation would need to verify in order to assure that conditions of probation, especially including the condition of no contact with children, could be meaningfully enforced, or we would have some sense that condition was being met in a verifiable way. And that, obviously, the case arises in a context, and the context is obviously serious crimes against a 12-year-old boy, which I take my brother's point that he has no prior criminal record or post record. These were indicted together and resulted in one group of convictions, but they occurred over a period of months during a summer in 2005. So is not appropriately characterized as a one-time lapse in judgment insofar as that was the implication, but rather was a pattern of gravely serious criminal conduct against the child. And in that context, a condition of no contact with children was essential to the mission of probation to ensure against recidivism. And in the current context, and I don't suggest this is necessarily the petitioner's fault, there would be no meaningful way to enforce that condition. We would really be just accepting his word that those were the conditions of his home, of the home where he would be released to. There would be no GPS. There would be no confirmatory home visit. So that is one point with respect to public safety. The other would be that this immediate release would override the normal process that is attended to release of potential SDPs. As the court is aware, the defendant's convictions and the fact that he's incarcerated at the present time qualifies him for potential evaluation as a sexually dangerous person, and this office is entitled 6 months prior to his release to notification by the custodial authority about his impending release. We have not even received that notice yet from the MTC about his upcoming release, which I concur with my brother that we believe it would be in mid-September. I believe the actual date is September 15th. That would be with maximum good time credit. That would be his potential release date. So it would override entirely that process and essentially prevent us from engaging in that review that's supposed to occur under the statute. And it's not merely a notice. The notice is supposed to be accompanied by information from the custodial authority about those who the custodial authority believes have a particularly high likelihood of meeting the criteria for a sexually dangerous person. Obviously, as set forth in the presentations of the DOC and the sheriff, it's very clear that they have information from daily contact with the defendant that we lack, and our offices rely on information like that in making SDP determinations. Now, with respect to the nature of the probation violations, I recognize that they are technical in the sense that they don't allege new criminal offenses, but I would refer back to what Judge Brieger found, which was, and I quote, a dismal pattern of noncompliance with probationary conditions. So that is another piece of necessary context here. What we have is not only the failure to attend the probation meeting, failure to attend the restrap, but essentially the pattern of non-attendance to these sex offender treatment visits. And I appreciate that my brother has explanation that he has proffered, but those were proffered in front of the judge who violated and ultimately sentenced him to 1 to 2 years. And those, to me, sound a lot like credibility determinations of a judge who is making them in real, with the information that is before her. So it's not clear that the arguments about willfulness will ultimately prevail. But even if we were to grant that in the context of a stay he could make that first prong, now Justice Ditkoff and in another sort of dimension, Justice Tochka have ruled that his release would not be consistent with public safety. Of course, Justice Ditkoff was focused on the possibility of recidivism, and Justice Tochka, I think appropriately, considered something that is really not the defendant's fault, but is nonetheless a valid consideration as to public safety when he's released. And this gets to that second piece, which is public health. Obviously, as put by one of my brothers, the Assistant Attorney General, we must be pretty sure that release would do more good than harm. Here we have someone who would be leaving an institution which has the clearest outbreak, unfortunately, of all of them. And what is clear from all the public health experts that have weighed in, and I would direct the court's attention particularly to the affidavit of Daniel Tasai, who is Deputy Secretary of Health and Human Services, that what would be appropriate upon his release from this institution, at the very least, is a screening, if not an outright test. And I appreciate the practical considerations raised in the Middlesex presentation regarding the lag time between any test and the results of that test. But at the very minimum, a screening. And then if he is found to be symptomatic, he should be held until he's confirmed. And then even further, that person has been, will need to make adequate provision for quarantine. And again, we're hearing for the first time what the plans are, and we appreciate that counsel has found someone, or the defendant has found someone that would house him, and that sounds appropriate. But there are sort of two competing considerations here, and that is, as Justice Kaffer put it, healthcare workers are on the front lines of this epidemic, and we know that they are unfortunately testing positive in the highest numbers of all professions. And so whether Mr. Christie would be more safe in that environment is unclear without some verification of what my brother is saying through, as far as he has been able to confirm things. And then finally, the defendant's own health and safety. It's certainly true that the advocates and my brother have done yeoman's work in attempting to arrange for the availability of support, both medical and psychological, on the outside were Mr. Christie to be released. And we can all agree on one thing, is that Mr. Christie is medically involved and he is psychologically involved, and he needs significant support. And they have done yeoman's work in attempting to arrange for those supports. But in the current environment, through the fault of no one, these can remain mere hopes and beliefs and expectations at this point. And the fact is that the situation changes by the hour, and there can be no guarantees about the actual availability of the necessary support on the outside. And I would note that with respect to the back surgery that I hope Mr. Christie gets sooner than later, the appointment was made and kept by the DOC on March 11th. So at least we know while he's in the DOC, he is getting to his appointment, he is making his appointments. By all accounts, it appears that that surgery is now postponed. But yeah, at least we know he has some level of care in that facility. And obviously, as set forth by the parole board, I think the DOC, in the last 6 months, there is a release procedure whereby we secure people's health insurance, and we put those supports together. And I'm not convinced that the judge was wrong in determining that it's not clear that this would benefit him more than potentially hurt him at this stage, given all we know. So with that, I'll open it up to questions.
Justice Feliciano.
Yes, it seems just a bit odd to say that if all things being equal and someone were eligible to be released, we would not release him if he was in the treatment center, because that's the center. So we're going to have to basically make that an island. I mean, I assume that you didn't mean it to come off that way.
No.
Once you're in the treatment center, you're going to stay there because that's where the infected people are. And the other part of the other side of that coin was that we're to presume that the state knows more about this person's health in what's best for him than the person does.
Yeah, I don't necessarily presume that. I just know what we know with regard to the care he's receiving right now, and I don't mean to suggest that anyone who's in the MTC must necessarily stay there. But I mean to suggest that someone as medically involved as him needs a very solid release plan and very solid supports, particularly for someone who's wheelchair bound, and also significant supports for public safety that would ensure against his the potential for recidivism, and of course his last SOAR classification was level 3. I don't know if that would change upon his release, but at least that was the last assessment of his likelihood of recidivism.
Okay. No further questions, Chief.
Justice Lilly?
Mr. O'Sullivan, you mentioned the standard of review of abuse of discretion. So your view is, as it relates to the security danger prong, that is, it relates to Judge Tochka, it would be an abuse of discretion, and then as to Judge Ditkoff, of course, they analyze different parts of danger and security.
Yeah, I think that's correct, Your Honor. I think we would look at Judge Tochka's effective denial of a stay motion. Of course, the petitioner sought two kinds of relief below. And on the one hand, he sought to have his sentence, the incarcerative portion of his sentence, deemed served and for him to be immediately released. And of course, Judge Tochka questioned whether he had legal authority to do that. Of course, this being well outside Rule 29 territory, and given the absence of any statute or other rule or case law that would permit any such thing to happen, he also considered it effectively as a stay, but referred back to Judge Ditkoff's denial of the stay and essentially, at least implicitly, adopted the reasoning of that. So I think the best way to read his decision is he viewed himself as having legal authority to act on a stay motion, but he just declined to issue a stay, and essentially, at least implicitly, adopted the reasoning of Justice Ditkoff, which again concerned public safety.
Is it something that we should be considering, that he would be moving in with somebody in the healthcare area, and that if he is in fact has COVID-19, that she would be working double shifts and bringing that to the healthcare facility with her? That's not necessarily the case. We don't know anything about her work other than she's a healthcare worker doing double shifts. But is that something we should really at least know?
I think it is definitely in the mix, Your Honor. Again, we don't. What my brother has represented, but we're hearing this for the first time, is that she would provide for adequate quarantine sort of situation there. If that is true, in any sort of normal living situation, that is very difficult when you're not living alone, when you're sharing a home with somebody. I don't think that is the sort of medically adequate quarantine that is contemplated by the health experts that have weighed in here. And I don't, if it's locking him in his room, he's still going to be using the same facilities, whether it be the kitchen or the bathroom. I didn't hear that there's a separate apartment in which he could stay that would, for 14 days, really seal him off from everybody, which seems like the best public health course to take at this point. But whether he may bring that in and infect her in that context, whether he may bring in COVID-19, infect her, and thereby endanger her patients is a valid consideration. I think this is all in the mix. And the need, and highlights the need for really detailed release plans for someone in this particular circumstance.
That's all I have, Chief. Thank you.
Justice Bud.
Yeah. So just with regard to the abuse of discretion standard of review, if that's what we're to use, where, if at all, does the change in circumstances, just, how quickly things have changed since the time that those decisions were made, how does that impact the analysis, if at all?
Well, I think that to talk about additional positive tests, if that is that what Your Honor was referring to?
Yeah, I think the first time he, I can't remember exactly whether there were any. I don't know that there were any cases when he first moved, and then it just steadily began to rise, and it just seems like it will continue to, because that's what goes on. So yeah, that's what I'm talking about.
Yeah, well, I would just note at the outset that obviously any new test is concerning, and here in the particular case on March 24th, when he filed his emergency petition to renew the 211.3 in front of Your Honor, there were 4 positive cases, and 2 days later, when you reserved and reported the decision, Justice Budd, there were 11 positive cases, so that's an increase of 7 over 2 days. The current, and I got an email this morning, and it's now been confirmed in the hearing by the DOC, is that between that day, which is March 26th, and today, March 31st, 5 more days, there's 17 positive inmates. So that's 6 more over 5 days. So that is, of course, we don't like any new tests, but that represents a rate of increase that is lessening. And so that is potentially a hopeful sign in that respect. But of course, any new test is concerning. It was also somewhat encouraging to hear that those who have the new tests that have tested positive, that is the 6 more since March 26th, were people who were already quarantined, and presumably they were in the cohort of people who were in contact with the first positive test. So those people were already set aside. So this is some indication that the extraordinary measures that the DOC is taking are hopefully helping to curb what could conceitedly be, a terrible situation in there. So that is something to note at the outset. But obviously the situation on the ground at the particular institution where they are is something that the judge should be able to consider in exercising discretion. And that could change and from minute to minute. But is it possible for him to renew this motion before Judge Tochka or another judge in the Superior Court? Yes, with more information, they may make another case and, frankly, allow the judge to evaluate any release plan and whether it comports with I would suggest, are not insignificant public safety concerns here and public health concerns and concerns for the defendant's own health and safety.
Has there been any discussion between the parties about whether this was potentially possible, or was it the DOC's position that no, that's not going to happen here?
I'm sorry, Your Honor, that his release?
Yeah. I mean, did you guys ever have any conversation about whether this was a possibility, or was your position always that this would not be a good idea?
Well, we didn't have the information that we have just received.
Right.
Which is, that was key information that we lacked, that was clear in all the pleadings from our office and all the pleadings from the probation service from the outset, which is that we don't have perhaps the key piece of information you need to evaluate the safety of a release plan, which is where you're going to stay. So in answer to your question, whether we've had conversations with counsel or the DOC, we've communicated somewhat through our pleadings about our concerns about the release plan.
Right.
Yeah.
Oh, no, I understand. I guess my point is, now you have more information, and is it now a possibility that if some of these details were nailed down and probation was comfortable with the living situation, is it something that the parties could come together in some sort of agreement about?
That is possible if again, but conditions of probation with no meaningful, means of enforcement amount to no conditions, and that would essentially flout the order that the sentencing judge gave. So, with that in mind, of course, if we are presented with, we don't want to put Mr. Christie at unnecessary risk. If there's a parole plan or rather a release plan that makes sense, it's certainly possible, and we have in other cases agreed to release. So, yes, in answer to your question, in short, yes.
Okay, yeah. I ask because I genuinely want to have a sense of whether there's some bend here, but also you keep saying that he'll have no conditions. Well, but that's the case for every probationer out there right now. I mean, the problem is we're only talking here. We're only having this hearing telephonically because of the pandemic, and so I'm just thinking these are extraordinary times, and we're just all here trying to figure out how to handle them. And so, I understand that it's important to be able to monitor people, and in the regular course, that's absolutely what I know is done and done very well. But I'm just trying to figure out what we do in this particular, given these set of circumstances. And so that's why I asked about that. I've got one more question. Is there anything that the treatment center has considered doing for Mr. Christie, given his particular needs and vulnerabilities?
I am not aware of particular things beyond, obviously making medical appointments for him, ensuring he gets his medications, and providing him access to any needed medical care.
I mean, sort of keeping him away from, keeping him isolated from possible exposure, that type of thing. You're not aware of that?
I'm not aware, and I'm not aware of whether he's availed himself of any sort of internal complaint process whereby he might seek something like that. Yeah. I don't know that there, for example, in his 6-man room, whether there aren't people who would, share medical conditions that might make them more vulnerable too. For example, where I just don't know how many people there would be in a similar boat with respect to a medical condition that they could say makes them more vulnerable. Yeah. I think what the goal of the SJC or the DOC, as made clear in today's hearing, was to secure the safety of all their inmates. And obviously, there are a lot of people there who are medically involved.
Okay. All right. Thank you.
Justice Seifer.
Yes, just one point of clarification. On the friend who said that she would take Mr. Christie in for quarantine and he would be quarantined. Is that a 14-day quarantine contemplated to somebody who's exposed, or is that a long-term quarantine situation such as we're all under?
I believe it is a medical quarantine that is more, sort of strict than what we are all doing as sort of society. I believe in, and I'd refer to the Daniel Tsai affidavit. He may either set that forth himself or refer to a CDC or DPH, authority that may lay that out. But I think it's more than what we're going through. He really needs to be isolated to the extent possible, so that there's some assurance that he is not a carrier.
Okay, so in other words, it'd be a more intense but shorter medical quarantine, and then he'd be in the same position everyone else is in.
I believe so, Your Honor.
So in that case, my question is she still available as a place to stay after that more strict medical quarantine?
That is unclear to the Commonwealth, and I don't remember whether my brother said whether that would be a long-term placement or what. I know in his filings with the court, his plan was to get his back surgery, I believe convalesce at the home of a friend, and again, we're hearing for the first time who that is, and then after that to secure a placement, I believe, in a boarding house, but I'm not entirely sure about that.
Okay, thank you. No more questions.
Thank you.
I have none.
Okay, I've got a few. Mr. Sullivan, you said that Judge Tochka agreed with Justice Ditkoff. If you have the opinion in front of you, I'm turning to page 8. As I read it, he basically says, the court, on the top, the court declined to treat the motion as a motion for reconsideration, because essentially Judge Brugger would have to do that, and she declined to do that. So the motion to reconsideration, he says, is not for me to decide. Then all it says as to Justice Ditkoff is, as to Christie's alternative request that this court stay the execution of the sentence, the appeals court single Justice Ditkoff J. already denied this request on February 26th. Is there anything, as best I can read, he basically thought that Justice Ditkoff's denial foreclosed him from considering whether or not there should be a stay of the execution of the sentence pending appeal. Is that correct? Am I right?
I wish that were clearer. That is a possible reading of that sentence, but I think.
What's the alternative reading? Where do we find your reading where he basically says, "I agree with Judge Ditkoff"? I reach the merits of it, and I come to the same finding.
Right. Well, he goes on to consider the only changed circumstance, which is COVID-19. In the next sentence, he says, the issue then is whether this court may unilaterally, if you skip down a few paragraphs, the last paragraph, he goes on to consider the only changed circumstance that's at issue, which are, the additional, positive tests there. And he says there's an issue as to whether his immediate release would pose a danger to the public simply in terms of spreading COVID-19. He would likely have to be quarantined for a certain period of time prior to or after release and then possibly tested for COVID-19. So I would submit that it's not entirely clear, and I agree with Your Honor, but a fair reading is that since he did consider the only other changed circumstance, that he said, I would deny the stay, given that additional potential danger to the public.
He never says that, though.
He never explicitly says that.
Well, he says there is an issue as to whether, and he recognizes that once released, it's unclear as to whether he would engage in practices. It's unclear. And he said this presents further dangers to the public. So, yes, of course, there is a danger if he would be released. But I don't understand how you say that he made his own independent determination as of the date of the decision, which is March 26th, as to whether or not to deny the stay. I guess you're resting just on that last paragraph, the finally part of page 9?
Yeah, and insofar as it needs remand for clarification, that would be fine. But my reading of it, and I agree it's not entirely clear, is that he would deny the stay as well on the ground of COVID-19.
And is your view that it's appropriate to deny release to an individual who is at risk of getting COVID-19 because of the fact that they may pose a risk to the public, that this would be essentially treated as a civil commitment?
Well, no. I mean, what we know, unfortunately, about the disease and about those who have been exposed to persons with it and contract it is that they're asymptomatic for some period of time before, and they can transfer it during periods of no symptoms. So, yeah, I mean, is that a legitimate public health concern? even absent a positive test that would justify quarantine, well, that is the judgment of the public health experts that have weighed in.
So your argument, let me understand, your argument is that those most at risk of getting COVID-19 in prison are the ones who should be the ones who should not be released because they may potentially pose a risk to the public, that a reason to hold somebody in prison is because they have a substantial risk of getting COVID-19. Is that your position?
Well, but Judge Toshka,
I'm asking about your position. Is that your? I mean, that's an argument that's analogous to what Justice Gaziano asked. Is it your position that does your office say that it is a reason to not release somebody because they may pose a risk to the public if they are released from jail or prison, and therefore they must stay in jail or prison?
Well, if we take as a benchmark of reasonableness the special master's proposed order, I believe if someone does test positive, they must be held and quarantined for at least that period of time. So, so with respect to, people who potentially present a risk to those on the outside, obviously there is a difficulty in saying precisely the people who are, at risk are the people who we should keep in because they're at risk. But to the extent they have been exposed and we have good information that they were exposed, and Mr. Christie seems to think he was directly exposed, although I don't, thank God, understand him to be reporting symptoms. It's definitely a relevant public health, consideration that he may be positive for it. And relevant in that regard is the fact that at least at the prison, he would have immediate provision for quarantine and treatment. And I appreciate that our whole medical system, including that at the DOC and that outside, is overburdened. But I would submit that Judge Toshka wasn't wrong, and it is a relevant consideration in the position of our office that he could potentially infect other people on the outside. But I definitely appreciate Your Honor's question and the point that animates it.
Okay. And I guess finally, if we were to read Justice Toshka's decision as saying that I can't consider the motion to stay because Justice Ditkoff had denied it on February 26th, that would be error, would it not?
Yeah, that would be error. Yeah, and any reading of it that he believed himself incapable of considering a motion to stay based on a changed circumstance, that could be error. Although I would suggest that there isn't exact guidance on this particular issue out there, but I would submit that would be error. That would be that the judge would have engaged in if he hadn't considered that. But again, I think fair reading is he had.
February 26th, I think, just from our world, is before our March sitting, which we had as a routine sitting. And by March 26th, we were in a world in which we were dealing with only emergency matters. So the world changed fundamentally between February 26th and March 26th. Don't you agree?
That is fair.
That's all that I have. Anybody else? Justice Gaziano, any further questions?
No, thank you, Chief.
Justice Lowy?
All set, Chief.
Justice Budd?
No, thank you.
Justice Seifer?
No, thank you.
Justice Kafka?
Well said. Thank you.
All right. We thank you all. This concludes our hearing on March 31st. Thanks to Clerk Keneally for all of your work, and I will confer by email with the justices as to our timing for sample. Thank you.
Thank you, Chief.
Thank you, Your Honor.
Thank you.